Hey, everybody, and welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel, doing what we do each and every Thursday night, which is doing this live stream to talk about all things debt related, to go over questions, discussions on ways you can deal with serious debt problems, whether you're dealing with, facing bankruptcy, debt collection lawsuits, wage garnishment. We're going to go all through that. So, today, I want to do something a little bit different. So we have some questions already in the chat. I want to go over those. And if you have questions you want to discuss, put them in the chat section, whether you're on YouTube, whether you're on Facebook, and we'll go over them. I give my weekly disclaimer. While I am a licensed attorney in the state of Arizona, I'm not licensed anywhere else. And so take it for what it's worth. Some guy talking on YouTube. If you're in Arizona and you want to get in touch with me for a consultation, we'll put my information below here shortly. Even if you're not from Arizona, I'll put a number down there where you can get in touch with someone who does what I do. I also want to do something today a little bit different, that I want to talk about something I saw on the internet the other day. And I was watching a trial. A lot of trials nowadays are live streamed on YouTube, so you can watch the actual what's going on with the trial. And there's a trial going on that I have some interest in. Many of you are probably familiar with this Chad Daybell trial, and you can put in the comments if you are, if it's something that you're familiar with. It's this trial that's going on. It has some connection to Arizona. This Chad Daybell, Lori Vallow. It's a criminal trial. It's a murder trial that's going on. And excuse me, I start these every week thinking that I'm all ready to go. And I usually jump into a live stream right after doing a whole day of phone consultations, and it gets a little bit tricky. So, but anyways, back to this criminal trial that's going on right now up in Idaho. It has some connection to Arizona. It's a murder case. It's been on the news, all the datelines, all that kind of stuff. I was watching it, and I was watching this attorney do his cross-examination, and I was watching the live stream, and all these people are just beating up on this attorney. And it's easy to beat up on a criminal defense attorney because, we don't like exactly what's going on there. But the technique, as far as what the attorney was doing through cross-examination, was correct and appropriate. It made me think of a lot of you that are out here getting ready to go to debt collection trials. People always reach out to me saying, hey, I get nervous about how to do that. And so after we go through some of these initial questions, I actually want to show you some video of the cross-examination. Now, here's kind of the clincher of really why I have a ton of interest in it, is because the defendant in this case, Chad Daybell, I actually grew up with him in the same town, and I know Chad. And so this whole thing, as it's unraveled, has been completely and totally mind-blowing to me. I grew up in a town called Springville, Utah, and the even more weird twist, and maybe I shouldn't share this about my youth, is that I worked with Chad in high school. And where we worked in a graveyard together. We worked at the local cemetery. The sexton, the manager over the cemetery for our little small town, was a guy that I went to church with, and he would give teenagers in our congregation in our town, give jobs with the city for the summer, where we would take care of the grounds, and we would even do the burials at this cemetery. And so I worked with Chad Daybell for many years in the cemetery. And so that's kind of another layer to it. I worked with his wife, who he's accused of murdering. And I know this is all way off of what we normally talk about. But I thought, in watching this video, this trial, there's some things that you can learn from it, particularly if you're facing a debt collection lawsuit. And so after we go through some of the questions here in the chat, if you want to hang around, I'm going to walk you through some of the video about what the cross-examination is, why the attorneys are doing what they're doing, and how it can help you in your case. You can actually learn from some of these things that are kind of in mass media, and we can talk about that. So, but again, that's way different than what we normally talk about, but I'll talk about there after we go through some of the questions. So Claudia was here nice and early. Claudia says, is it possible to have a judgment that results in a lien on your home for a credit card debt? Yes, it's absolutely possible. And it's one of the reasons why collectors and creditors want to do it. It's why they pursue it. Is because so a credit card is an unsecured debt. That means that there's no collateral, there's no property attached to it. And so in order for them to have any real teeth to be able to do anything, they have to sue you, get a judgment, and then what they can do is they can record it in the county recorder. Most counties throughout the country, all counties have it. It may be called something different than the recorder, but like in Arizona here where I live, the Maricopa County recorder, you can go and record that, and then it acts as a lien against any real estate that you have in that particular county. Now, so what's the result of that? The result is that when you sell the property or you refinance the property, they're going to get paid after you pay off your mortgage, after you pay off any, if you have a home equity line of credit or something like that, they will get paid through those proceeds. You also have your exemption, a homestead exemption. So it does act as a lien. It doesn't mean they're going to get paid automatically. It doesn't necessarily mean they're going to foreclose on your home or anything like that. But yes, Claudia, it's absolutely possible. It's a good question. Joe says, if I'm definitely going to be filing for bankruptcy in the next 3 to 6 months, when should I stop using credit cards? This is a good question. I get this question a lot. Actually got it just today here in my law practice in Arizona. And my advice is once you have made the decision to stop or to file for bankruptcy, I would stop using the cards. The reason being, there's several reasons, but the legal reason is that if you, under the bankruptcy code, if you make charges on a credit card in the 90 days prior to filing for bankruptcy, or if you take a cash advance out on a credit card within the 70 days prior to filing bankruptcy, that the creditor can come in and object to those specific charges if they were for luxury items. Now, the bankruptcy code doesn't describe or define what a luxury item is. Courts have said, people that use their credit cards to buy gas and groceries and diapers for the kids, those are not luxury items. But it is something where you run the risk that the creditor is going to come in, raise the objection to those charges, and then those specific charges would not go away. My practice is I don't see this happen a lot. In 20 years of doing this, I've had it happen once, and it was for a very egregious one that we knew was going to happen. It was a business charge of about $20,000. So we knew that was going to happen. But my recommendation to clients is once you make the decision, I would not make any more charges. It's going to cause you problems, and I wouldn't do it. I would just stop once you actually make that decision to file the bankruptcy. My man Alex down in Yuma, here as always, it says, in Justice Court case, answer was filed over a month ago, no activity, no disclosure received. What's your next move? This is fairly common, which is surprising to a lot of people, is that the case gets filed, they serve you, you file your answer. And part of it is maybe they're in shock because you filed the answer. 95% of people don't file answers. So you filed the answer and then it just sits there. My personal opinion is what happens is these debt collection law firms, I'm speaking from my experience in Arizona, they have a lot of cases, hundreds of cases, maybe thousands of cases, and don't have a lot of people, they don't have a lot of attorneys running them. And so when you do file an answer, there may not be someone that's pushing it along. Justice court cases in Arizona, there is a rule that says the case needs to be completed within 10 months. So if it's been over a month ago and nothing's happened, you can reach out to the other side and ask for a copy of their disclosures. The court will be setting a pretrial conference in the near future, which is really kind of the first time when the court becomes aware of it. They bring the parties in and set some different deadlines. So that will move it along. But if you're in a case where there's been no movement for a long time, I've done this in justice court cases where we're almost at 10 months. I'll file a motion to dismiss for lack of prosecution. Often the courts will give them another opportunity to try to get things back on track. But if it's been a really long time, they may not. All right. Let's see here. JDB, junk debt buyer, is suing me for 4 separate accounts in one lawsuit. Got arbitration approved by the judge. Do I file one single arbitration with JAMS or 4 separate ones? I would just file it all as one. So 4 separate accounts. Is it same? I guess you can put in the comments. If it's the same junk debt buyer, I think you can file it all in one proceeding. If it's different junk debt buyers, if you have portfolio recovery, Midland funding, and LVNB, you need to file 3 separate ones. But if you're dealing with the same junk debt buyers, just 4 underlying accounts, I would file it all as one. because I think that's going to put you in a better spot, and it's going to save you that filing fee, because you are going to have to pay a filing fee for each and every one of those. Randall, how are you doing? I owe you an email. It's giving me a thumbs up here. Thank you for being here tonight. So, but yeah, back to your question. I would absolutely, I would go ahead and if it's the same junk debt buyer, just go ahead and push forward. And that's going back to a lot of times I talk here about filing a motion to compel arbitration to get the case out of court into an arbitration like JAMS or the American Arbitration Association. I have faithful watchers of my channel have noticed over the years, I've changed my tune on that. I used to say, wait for them to file the arbitration because it's them who has the claims. I don't really agree with that anymore because I've had too many judges that, the creditor comes in and say, look, they didn't file their request for arbitration. And so, and then they push it back into court. I say, just go file it. Whether they're going to follow you into arbitration or not, it's not going to be dependent on whether you file it or they file it. I would just go ahead and file it. So, okay, well, let's look at this thing on cross-examination. If you're just joining us here, I'm going to do something a little different. You can still put questions in the chat, and I'll get back to them. I wanted to show you, and I'm doing this kind of on the fly, so this may not be completely smooth as I want it to be, but how to do a cross-examination. And I'm bringing it up in the context of this Chad Daybell trial, which is going on in Idaho. And I mentioned to you earlier, if you're just getting here early on, I know Chad personally. I used to work with him when I was in high school. I haven't seen him since then, but I worked with him in high school, and I actually worked with his wife that he's on trial being accused of murdering. She worked for the city as well. But I was watching his trial on YouTube, and I was watching the defense attorney do the cross-examination. Like I said, in the comments, everyone was just blowing him up over the defense attorney as far as what he was doing. And I wanted to walk through that and show you how a defense attorney works, to be able to show you exactly what they're doing and why they're doing what they're doing. So let me see if I can do this like in a full screen. I think we can do that. Like I said, we're kind of working this on the fly. But so this is from the East Idaho News. They do a live feed. The court actually does a live feed. And so what you're seeing here on this one is this is the Zoom feed from the court. You're seeing in the upper left a view of the defense table. So that's Chad Daybell, where his attorney is. Then they're doing the view of the judge and the witness. This particular witness is a police officer. And then you're seeing the screen that the jurors are seeing. And then you're seeing the prosecution table as well, the state. Real quick thing, and this can be kind of a trial, a boot camp version of this. If you are in a trial, if you're going in for a debt collection trial and you walk into the courtroom, a lot of people freak out and say, I don't know where to sit. And I know you're thinking this because I thought this as a brand new attorney. The defendant usually sits away from the jury box. So the jury box is where all the jurors sit. You usually are sitting on the opposite side of that. Now, something in smaller courts, like small claims, justice courts, often they'll even have little signs on the table saying plaintiff, defendant. But if you go in and there is a jury box where the jurors sit, you can usually go to the other side of that and you'll be okay. That's how I do it. That's how I think of it when I go to court, even now, 20 plus years later. Okay, so in this case, the police officer was called as a witness for the prosecution. And now the defense attorney is cross-examining. So the defense attorney here is doing a cross-examination of the police officer. And I want to go through how he asked the questions because it's going to be relevant to you if you're doing cross-examination, like of a credit card witness, custodian of records, that kind of thing. So let me see if I can make this work and we'll watch a bit of it.
Now, obviously, during your talk with the prosecuting attorney, this has already been admitted. And you went through that. You recall that, right?
Yes.
Now, as part of your examination, you provided records from Fremont County Sportsman's Club, right?
Yes.
And you did the start date of sometime of 10/16. Is that right? Is that what you recall?
The start date of,
Of when the documents that you provided to the prosecuting attorney, the first entry on there, it looks to be about 10/16. Am I mistaken?
I'd have to relook at those.
Okay, Judge, could we show this to the witness to refresh his recollection? When you're done, just hand it back. Thank you, sir.
Okay, let me tell you just one thing really quick. Two things right off the get-go that you're going to notice. You're going to hear the cross-examination, the defense attorney. He's going to end most of his questions for the witness with correct or right. And that's because you're able to, and you're permitted under the rules, when you are cross-examining someone, that you can ask leading questions. Sometimes you'll hear on TV, objection, leading. If you're doing this as a defense attorney, if you're cross-examining someone, frankly, all you want to ask is leading questions. And a leading question is where you are leading them to a particular answer. So, saying, now the date on this thing is March 21st, 2019, correct? You're wanting the witness just to agree with what you're saying. And I can kind of show you how you can do that in a debt collection context. And then the second thing we're doing right now, if you have a witness on the stand and they don't know or can't recall something, you can provide them something to help them refresh their recollection. So here, the defense attorney, the police officer said, I don't recall that specifically. And the defense attorney said, okay, well, Judge, let's give him this to refresh his recollection on that. So police officers are going to look at his report.
Yes.
Real quick note, if you have a witness and you're in court.
And Your Honor, may the state know what's being shown to the witness?
Which exhibit did you just
It's-
reference?
Okay, this is real quick point. First point is, if you ever need to take something up to the witness, and like if you're cross-examining like a junk debt buyer's witness, there's going to be a lot of documents. You should always ask if you can approach the witness. That's a protocol on this. You don't just walk up there and give the witness the document to look at. You need to say, Your Honor, may I approach the witness to provide them with a copy of this document? And then the other thing that you just saw there, so they provided the witness, the bailiff did it for the attorney, took that up to the witness, to the officer, so he could look at it. And then the prosecutor, she said, hey, Judge, we need to see a copy of that. So when you're preparing, if you have documents that you want to use and present at trial, whether it's on your own witnesses or cross-examining the others, you need to have the original copy, but you always need to make a copy for in your case, it would be the plaintiff's attorney. Here it's the prosecution. So she said, hey, Judge, can we see a copy of this? Because we need to be able to see it as well.
For exhibit of the entries to the visits to the Sportsman's, I don't want to misstate the name of the organization, Sportsman's Gun Club.
Thank you.
That is exhibit 390A. I'm sorry, 396A.
Okay, and if I could have that back.
Okay, so the memory's been refreshed. The bailiff brings this back to the defense counsel, and then they continue on with their cross-examination.
Now I'm looking at this exhibit and it appears that it starts on 10/16. Is that right?
That's correct.
Okay, now did you happen to take the time to look at the entries prior to that time?
Prior to 10/16, yes.
You did.
Yes.
And Alex Cox arrived in Idaho from what you learned from your investigation about when?
On the 1st of September.
So on the 1st of September. So after arriving, as part of your investigation, what did you discover from September 1st to October 15th in terms of the number of times that Alex Cox visited the gun range?
Give those dates one more time.
September 1st we'll just make it October 15th.
So Alex Cox, from my knowledge, was at the gun range in St. Anthony from October 7th to the 16th.
Okay. And you don't have any entries of him being there in September?
Not at the Fremont County gun range, no.
Do you have him at any other gun range in the month of September?
I believe there were some in Rexburg, Idaho.
Okay. And when you say some, that would indicate that there were more than 2 or 3. Is that right?
Correct.
Okay. So he'd had a habit. You also had an opportunity to review the searches of Alex Cox on his computer as well, correct?
I don't believe on his computer.
You
no.
didn't review any of that?
I reviewed some of the Homer J. Maximus. I'm not sure if that was off of his computer or not.
Okay.
One quick thing here that, I mean, and this is a gigantic case, but one of the rules of cross-examination are that you don't ask questions that you don't know the answer to. And obviously this is a 6-week trial they're doing. So there's going to be some of this, but sometimes when I hear defense attorneys in the civil or criminal realm asking questions, and then the witness is like, yeah, no, I don't know. That's totally not right. Makes me wonder, how well they prepared for that particular witness.
But as part of the Homer J. Maximus, are you aware that Alex Cox had been looking at weapons as early as 2017?
I was not aware of that early. No.
Okay. Well, how early were you aware of when he was looking at weapons?
September, October of 2019.
And that's because that's when you went, that was your reference point. September 1st is when you started your reference point, right?
What I looked at, yes.
Yeah. So you didn't really go back and look at all of the searches that Alex Cox conducted prior to September of 2019, right?
I did not.
Okay.
And so do you see how he keeps saying, right? Essentially, so what the defense attorney is doing, and what everybody was just blasting him for in the comments is like, why is the judge letting him testify? In essence, that's his job. His job is to get a narrative of facts that he wants the witness to just really agree with. And so that's why, if we're using this an example, let me use you a real quick example I do often in a trial when I'm cross-examining like a junk debt buyer witness. But usually the only witness that usually appears at a junk debt buyer type hearing will be the witness for the junk debt buyer. So let's say if you have a case against Midland Funding, you're not going to have the original creditor's witness there. You're going to have someone from Midland Funding there. And when I'm cross-examining them, I will say, assuming that I know all this, one of the first things I'll say is, now you don't work for Citibank, correct? Correct. And in fact, you hadn't even reviewed these documents prior to the last, 2 weeks, correct? Correct. And then I'll get the bill of sale up there. And I'll say, now this bill of sale that we've gone over from Citibank to Midland Credit, it doesn't reference any specific account names or numbers, correct? And they have to agree, correct, it doesn't. And I'll say, and also it doesn't reference my client's name or account number, correct? Correct. And so you're getting them to eventually use this, you're getting this information out, the knowledge out, to be able to have the court hear essentially what you want them to hear. So let's watch just a little bit more of this, and then we'll jump back into some of the questions.
Okay. But you are aware that Alex Cox has a history of engaging in the use of guns or other weapons on folks, right?
So this is a perfect example. That defense attorney, they're trying to point the finger at somebody else. They're wanting to get this narrative out. And so the difference between a leading question and a non-leading question, a non-leading question is if I were to say, hey, Mr. Vince, Detective Vince, what happened on this date? As opposed to saying, Detective, now this and this and this happened, correct? So instead of just leaving it open-ended, which is a non-leading question, which is what the prosecution or the plaintiff has to do, when you're on cross-examination, you can actually do those leading questions. So that's a good job what he's doing there. Let's watch this a little bit more.
Objection, Your Honor. States facts not in evidence.
Overruled.
Okay. Maybe I could so I didn't realize we got the objection here. Let's listen to the question one more time and then
The Fremont County gun range, no.
Do you have him at any other gun range in the month of September?
I believe there were some in Rexburg, Idaho.
Okay. And when you say some, that would indicate that there were more than 2 or 3. Is that right?
Correct.
Okay. So he'd had a habit. You also had an opportunity to review the searches of Alex Cox on his computer as well, correct?
I don't believe on his computer.
You
no.
didn't review any of that?
I
we found
reviewed
out a-
some of the Homer J. Maximus. I'm not sure if that was off of his computer or not.
Okay. But as part of the Homer J. Maximus, are you aware that Alex Cox had been looking at weapons as early as 2017?
I was not aware of that early. No.
Okay. Well, how early were you aware of when he was looking at weapons?
September, October of 2019.
And that's because that's when you went, that was your reference point. September 1st is when you started your reference point, right?
What I looked at, yes.
Yeah. So you didn't really go back and look at all of the searches that Alex Cox conducted prior to September of 2019, right?
I did not.
Okay. Okay. But you are aware that Alex Cox has a history of engaging in the use of guns or other weapons on folks, right?
Objection, Your Honor. States facts not in evidence.
Overruled.
Okay, so what happened there is that's when leading questions went a little too far, is where it wasn't just trying to get him to agree with it, but he was trying to get him to agree to things that just don't exist. So in like a debt collection lawsuit, an example is if you were cross-examining it and saying, now you would agree with me that it's not actually me, but maybe there's some identity theft or something that hadn't already been introduced. And so the prosecutor objected, saying that it assumes facts that aren't in as part of that aren't in evidence. The court overruled it though. So the court let him, and you'll see, even when you're in court, the judges, that's their job. And particularly in a jury trial, the judges don't decide in a jury trial guilt or innocence. They're more like umpires. They're calling balls and strikes here. And so the prosecutor objected to it, saying, it assumes facts that are not in evidence, and he immediately overruled. And so he let the question go.
Are you aware, and I'll rephrase that, you're aware of the situation regarding Brandon Boudreaux, right?
Yes.
And you're
There's another one, and I'm sorry, I keep stopping this, but see, so he corrected, the attorney even corrected himself. He was going from an open-ended question, are you aware that this happened, to a leading question saying, you're aware, correct? And then he was able to say yes.
aware that it's alleged that Alex Cox at a long distance shot at Brandon Boudreaux, correct?
Yes.
Okay. And you're aware of Charles Vallow, correct?
Yes.
You're aware that Alex Cox took a gun and at close range murdered Charles Vallow, correct?
Yes.
And you're also aware that in both of those instances, Chad Daybell has not been criminally implicated in either of those cases. Is that correct?
Yes.
And Chad Daybell has not been charged in either of those cases. Is that correct?
Correct.
Okay. Are you aware?
Really effective, rapid fire questions. And so if you're preparing a cross-examination for a debt buyer, I've done over 450 trials and arbitrations. And I've got those questions down. I like to start off with saying, one of my first questions that I ask him is like, you agreed that, the debt buyer didn't ever enter into any contracts with my client, correct? Correct. We're looking at the bill of sale. This bill of sale doesn't include any account level information like account numbers, names, correct? Correct. And it doesn't include my client's name, correct? Correct. And you're getting them to agree with your narrative and bringing this out to the court to look, there's problems here. That everything that they're saying that's just trying to infer it, it doesn't really work.
Of any other instances where Alex Cox engaged in conduct towards other people with the use of any kind of a weapon,
Of a firearm?
any kind of a weapon?
I know that there was an incident with Lori's.
Objection, Your Honor. May we approach?
Yes.
Okay, the reason why if there's a, so usually an objection has to be stated immediately. And usually, at least in Arizona, some courts are different. The courts do not allow what are called speaking objections, and particularly when there's a jury involved. A lot of debt collection trials are not jury trials. Actually, very few are. Most of them are bench trials where it's only the judge. They will allow what's called a speaking objection, where you can say, objection, hearsay, these documents aren't this or these documents aren't that. In a jury, it's very controlled what the jurors actually hear. And so in this situation, the prosecutor has an objection with the question that was asked and is then asking for the attorneys to approach. And so the attorneys will then go up to the bench where the judge is. Depending on the technology of the court, like I know in some courts in Arizona, they actually will have the jurors put on headphones and it'll have like white noise in there so they can't hear what's being said. There's a microphone that's on the bench, particularly in video trials like this. The judge will turn all of that off. They'll turn off the microphone so we can't hear it on the live stream. And the attorney the prosecutor is going to bring up her objection because clearly there may be some prejudicial things. There may be some legal issues that the courts have already said that they can't bring up, and they want to just get it dealt with before the jurors can hear it. So that's why she's asking to approach the bench.
All right, thank you, counsel. We took up a evidentiary ruling outside the presence of the jurors. Mr. Pryor, you may continue with your cross-examination.
So there was an evidentiary issue in the air whether there was an objection. So an issue of law based on the rules of evidence, whether something is to come in or be excluded. They dealt with that issue without the jurors present so that they couldn't hear. And then the judge moved on once that issue was resolved.
So we talked a little bit about the fact that you're aware that Alex visited the gun range in September of 2019, right?
Yes.
You're not aware of whether he had visited or went to any gun ranges when he was living in Arizona 6 months prior. You didn't look into that. Is that right?
That's correct.
Okay. Now, officer, this will be tricky. On your Homer J. Maximus, you talked about a number of searches. Didn't you recall that, correct?
Yes.
I think he almost said Homer J. Simpson there.
Oops, Judge, this is the Elmo. I'm sorry.
And what is it you're publishing?
Uh,
Okay. This is part of Exhibit 107B.
And this talked a little bit about the gun and the distance and everything else, correct?
Yes.
And what I'm wondering about is that the first one that says the Grendel drop 100 to 200 yards, correct?
Yes.
Okay, now Tammy Daybell's driveway, and you described it as the distance between the end of the desk there and towards this first section here, correct?
Yes.
And for a clear record, we're 30 to 40 feet.
Sure.
Okay. Now,
Okay, so I think you've got the idea there, but I thought it might be kind of interesting just to kind of see that. Like I said, that case has been interesting to me just because I know the people involved, and that's a weird thing. I can tell you if you ever have had that experience, particularly something like that. And it's been particularly weird because the guy who's accused of all these murders, not only do I know him, but never in a million years, in your high school, do you think that he was a super nice guy, when I was growing up with him. And so it's just been kind of an interesting thing. But there's things that you can see when you watch that, if you understand why they're doing what they're doing. And it seems just kind of random the way that defense attorney was doing their cross-examination, but there's a method to it. Trying to get out their version of the facts, trying to get the prosecution's witnesses to agree with them and their version of it can be the same thing. This may have been interesting enough to bring my own son to my channel today. Hey, Powell. Powell's my son. And he asked questions, are leading questions treating the witness as hostile? So what he's referring to there, because, you'll see, and a lot of this we always see in movies or TV, we're asking for permission to treat the witness as hostile. What that is the prosecution or the plaintiff in a civil case, like I said, they cannot do leading questions. They can't do a bunch of stuff like, and you see this with junk debt buyers. And I object to this, even if it's just a bench trial. You'll see this with the attorney for a creditor. They'll say, now, Mr. Junk Debt Buyer witness, the amount owed is $9,652.32. Correct? Objection. Leading. And the reason why is because the plaintiff bears, one, they can't do the leading questions like that. They've got to prove that. They should be asking questions like, hey, Junk Debt Buyer witness, what's the amount owed? And they should say, okay, it's this. And then they should say, okay, and how did you come up with that? Not just doing some conclusory, hey, here's what the amount owed is. But if the witness, if you are a plaintiff or a prosecutor and your witness goes rogue on you, you see this in the criminal context where maybe they have a witness that they thought was going to be one of their star witnesses to help them, but all of a sudden they're testifying just totally, off script. They're completely off of what was expected. The prosecutor or the plaintiff's attorney may ask permission from the judge to treat them, the witness, as hostile. Not hostile meaning that they're going to fight, but hostile meaning that they are no longer our friend. We thought they were our friend. We thought they were our witness. They're not our friend anymore. So we want to be able to treat them as hostile, which would then open up the ability to start asking leading questions without getting an objection from the defense attorney. So if the judge comes in and says, that's granted, you can treat this witness as hostile, then all of a sudden you'll start seeing rapid fire leading questions on that witness from the plaintiff or from the prosecutor. So hopefully that was helpful and of some worth. The junk debt buyers mid-long credit for same. This goes back to the question from earlier today, which we had up here. If there's 4 different claims, same junk debt buyer, I would bring them all as one arbitration so that you don't have to pay a bunch of filing fees. They'll just put them all together in one consolidated matter, and you'll be able to deal with them that way. So hopefully that was all helpful. A little bit out of the ordinary today, a little bit interesting as far as what we're doing here. If you do need help with your lawsuit, with your bankruptcy, whatever it is you're dealing with, anything down below, feel free to reach out to me in the comments below. I'll put a link where you can set up an appointment. I do free consultations to be able to see if we can help you from there. But I appreciate everybody checking in tonight, and we'll